We're here this morning for this breakfast briefing, the catchy title being "It's the most wonderful time of the year." The snow is gone temporarily, to conduct a legal audit and finalize year-end planning. So our panel of speakers is going to be talking to you this morning, giving you some ideas and thoughts. Hopefully you'll pick up a few pointers and ideas that you can leave with. And by way of introduction, we have Scott Lewis, and our speakers seated to the table to my left. Scott Lewis and Brian Dardis will be our first speakers. Scott and Brian are both members of the firm's business and corporate practice group. Scott will be pointing out some year-end tax planning suggestions from our tax department and outside experts in the tax area, and guiding businesses through key elements of a year-end legal audit with particular focus on buy-sell agreements and insurance to fund a buyout, as well as records retention policies, which is a real hot area these days in not only just day-to-day business, but in my area, which is litigation. Records retention is crucial. Brian Dardis, who's also a member of our partner and a member of our firm's business and corporate practice group, will discuss the importance of keeping accurate corporate records and an annual review of corporate records, as well as some preliminary examples of some items that should be reviewed and updated. Ron Friedberg is a partner in our litigation practice group. He's also the chair of our surety and insurance group. And Ron is going to talk to you about measures you might take with purchase and sale agreements to better protect your businesses on a going forward basis. And finally, Seth Briskin, who's a partner and chair of our labor and employment group, will be discussing the best ways to protect you and your companies from unnecessary and costly employment litigation in 2014. So those are always hot areas to be addressed. With that, I will turn it over to Scott Lewis.
Thanks, Peter. Good morning, everyone. We put on a presentation about 4 years ago, and we introduced it with the good housekeeping seal of approval, because maintaining a good corporate minute book, or an LLC minute book, as is more popular these days, isn't foremost on the minds of most business owners. It is, as it was, very important. My partner Brian Dardis will explain, all the reasons why. And 4 years ago, I laid out certain conditions for obtaining from Myers-Roman the good housekeeping seal of approval. This year, the conditions have been narrowed to 2. Listen carefully to what Brian has to say. And the second, read carefully I'll call it a seminal work, a short article written all of 2 days ago by me. That's part of your handout materials, captioned, "Why are corporate minutes so important?" It's worthwhile reading, I believe. And I'll share only one story, because it's a dry topic, but the story has left its impression with me, and it goes back almost 20 years. There was a dispute between 2 warring factions of shareholders. There was 50-50 ownership. There was a partially executed buy-sell agreement, no stock certificates, no share ledger, no minutes, no nothing. And then all heck broke loose. And the lawyers came, and one of the lawyers on the other side, came with the partially executed stock shareholders agreement and an unexecuted stock certificate, because one of the agreed terms was that if additional capital was provided, whether, regardless of form, additional shares would be issued. But there was no written document, and there certainly were no share certificates. So the attorney, who was not in this room, came with a stock certificate. My former law partner looked at the stock certificate. Interesting. Well, my client owns the company. No, he does not. He does not. It was an unexecuted stock certificate. It looked like this. It was never signed. There was nothing in the share ledger. And the most tangible evidence of ownership that would have supported that client's position was never attended to at the outset. And that is an extreme example, and not an example that Brian's going to reproduce, because it was one of a kind. It was And I think there's two gentlemen here who know my former partner who ripped up the stock certificate. And it's important. Brian, tell them why.
Good morning, everyone. Thanks, Scott. Can everyone hear me? Okay. I have been given the enviable task of waking each of you up at 8 a.m. on a Thursday with the riveting topic of corporate minutes. So everyone brace yourself, so we're going to have fun. But in all seriousness, I mean, it seems like it's a mundane topic. Keeping accurate and up-to-date minutes is a very important undertaking. And unfortunately, and I think mostly due to its mundane and seemingly mundane and non-urgent nature, it's an undertaking that often gets overlooked and just not done. Failing to keep accurate corporate records and minutes can have serious unintended consequences and effects. I'm going to give you a quick example. I do have some examples, Scott, believe it or not, as to why this matters and why we should care. That doesn't involve a stock certificate. It involves nothing, actually. A number of years ago at a firm I was with, we were representing a corporation in a lawsuit. This corporation got sued for what I'll call the bad acts of one of its employees. The corporation was in the process of going out of business, but it was generally insolvent. And the plaintiff's counsel wisely and astutely brought the majority shareholder into the lawsuit under a person in the corporate veil theory. Basically, that's a theory that the majority shareholder is an alter ego of the corporation, and any acts of the corporation were the acts of the majority shareholder. It's a way to get after the majority shareholder for the same liability as the corporation would have. Unfortunately, and I should note that we did not represent the company in their transactional work, they didn't have anything. They formed a corporation and they didn't produce any corporate records, no bylaws, no code of regulations, nothing. And it turned out to be, as discovery was going on, a very big uphill battle. And ultimately, the matter was settled, but it settled semi-favorably, but it could have been much easier to deal with and much less expensive for our client if he was able to produce corporate records to put the alter ego piercing the corporate veil theory to bed quickly. Like Scott said, that's an extreme example, but it's a real example, and these things do happen. And the point is, a lot of small business owners, they don't want to go through these, the mundane issue of just keeping simple corporate minutes and records, because it's one of these things like, I don't care, why does it matter? And the vast majority of the time, it's probably not going to matter. Nothing's going to come up until it does. And when it does, that little bit, that ounce of prevention is worth everything. So these are easy enough things to do. They're things that you should do or required to do, and it just makes life a lot easier and a lot less expensive when problems do arise. And sure enough, they often do. Scott mentioned his handout, why corporate minutes are so important, and I do encourage you all to bring it home and read it. It's really got some good information in there. But just to summarize it, I'm not going to read it for you, but the bottom line is, small business owners form entities, they form corporations and LLCs because these entities infer certain rights create certain rights and benefits for the equity owners. Basically, limited liability for those equity owners, and there are certain tax benefits depending on the type of entity and the type of the business. Simply put, these benefits and these rights can be compromised and even lost if corporate minutes and corporate records are not properly taken and kept. I mentioned in my example of piercing the corporate veil. That's a legal theory under which a claim holder can go after the equity owners as if they were the alter ego of the corporation. That's an actual cause of action under Ohio and other jurisdictions, and it's there, and you can easily protect yourself. A small business can easily protect itself from these claims by just keeping good records. It's as simple as that. It's not that simple, but it's the simplest, best way to do it. And then there's a number of tax benefits that can be lost or compromised, or the burden of proof with the IRS can shift if you don't keep good records. One of the good examples in Scott's memo is the expenses versus dividends. The IRS may disagree with your designation for payouts of employees and shareholders.
Brian, another excuse me, is a loan versus a capital infusion. If there are loans being made it doesn't take a lot of effort to have those loans properly documented in the ledger and properly evidenced by a promissory note, even if it's a demand note.
Yeah. And then another benefit that it's kind of buried in the bottom of this is, but keep good records, especially when you have a multi-member LLC or a multi-share corporation. It can really help settle internal disputes that arise later on. When shareholders form a company, everything's good, everyone thinks things are great, but things don't always end up great, and that's when it's good to have good corporate records and buy-sell agreements and operating agreements and whatever else you're going to have. I'm dealing with a company right now. We represent a 50% shareholder, and it's a pretty small company. And these guys formed, him and his partner formed this company about 12 or 13 years ago. They had great intentions because they bought this nice-looking corporate record book that's got all this nice stock paper. However, nobody filled any of it out ever. So it's got a bunch of blank, it's 30 pages of blank, nice stock paper. Well, these guys hate each other now. They're both taking salaries. They're accusing each other of stealing from the company. There's no agreement whatsoever as to who is entitled to what, and we're relegated to the Ohio Revised Code and case law to settle our dispute. And unfortunately, cooler heads are not prevailing because they both feel wrong. So a little bit of documentation would have helped go a great deal a way to help solve this dispute. So things don't always work out great. Disputes happen. Records and up-to-date records can help diffuse those situations. So that's a big part of the why. This is why we look at these things. I mean, it's just good housekeeping. Here, some of the things you're going to want to look at. So the first slide, the first couple slides are what I would call the quote nuts and bolts of business entity records. A corporation or LLC should have an annual meeting, an election of directors and officers or managers for an LLC, keep a share journal. These are actually requirements under the revised code for a corporation. So failing to do that if you have a corporation, you're actually violating the requirements under the law. LLCs, it's optional. It's not a requirement under the law. Your operating agreement may or may not require these things, but for the reasons I discussed, it's a good idea anyway. Share journals, there's a note here, ownership changes. It seems like an obvious statement that you should keep a written record of changes of ownership of an entity, and it is an obvious statement, but it doesn't always happen. I've dealt a number of occasions where, for example, I was handed a corporate record book once by a client who had become a pretty good client, and I glanced through it and I noticed there was a minority owner that owned about 10% of the company, and I said, "Well, guys, who's this?" And they said, "Oh, yeah, we forgot about him." I said, "Well, when's the last time you communicated with him?" I don't think anyone's talked to him in about 10 years. I said, So he hasn't gotten a notice of any, he's gotten no tax returns, no notice of any meetings, nothing from the corporation, nothing from the corporation in over 10 years. I said, yeah, he doesn't really own anything. He's just a little, minority member or minority owner. And I said, fortunately, we were able to deal with that, and he could have ransomed us, and he very well could have sued us if he sued my company, my client, if he chose to. It worked out well, but it could have been disastrous.
Ryan, could I interject for one moment? A lot of times, and lawyers are as guilty of this as many others, when an operating agreement provides for membership interest or membership units, we don't go the extra step to issue LLC unit certificates. Sometimes banks will insist on it, but even when banks don't insist on it, to evidence a pledge of interest, it's not a bad idea to have a minute book for an LLC. As Brian said, it's not required, but it's good practice, and we're getting we're training clients to adopt that practice.
Thanks, Guy. Another note on here in this slide is qualification to do business in foreign states. A business entity that operates or does any I'll call it material business for lack of legalese in other states is required to register in those states, usually with the Secretary of State. In addition to the initial filing, there are every state has different filing requirements, and failure to comply with those can lead to cancellation or penalties or other things depending on the state. Cancellation can have some unintended consequences as well. Anything from fines to potential liability for individuals, There's even, I think, 1 or 2 states that provide that contracts are set aside if the corporation or LLC was not in good standing. So, easy thing to monitor. You file, you docket it, and you just keep track of it every year, but important to do. Ratification, this is also part of the quote nuts and bolts. Ratification is simply the corporation or the LLC adopting the actions of its officers or employees, or adopting contracts entered into by the officers or employees, ratifying that it was indeed the corporation's intent. Oftentimes for bigger deals, it's done as the deals are completed, but it's a good idea just for the directors or the shareholders or the members just to ratify all the contracts entered into in any given year, just to clean house and just to make sure everything's clean. Some potential possible consequences. Contracts it could be argued that a contract should be set aside because it was never properly ratified. That could lead to potential arguments for individual liability on those officers or employees that executed those documents. Are these scenarios a little bit far-fetched? Usually, probably yes, but why create an arrow for an adverse party to put in their quiver when an argument comes? It's just not. It's an easy enough fix, and take care of it, and it's done. Also, there's we talked a little bit about tax ramifications. Provide some evidence to go to when the IRS comes at you and challenges what a dividend was or something like that. You have some evidence that, listen, we talked about this. It's in our minutes. We adopted it. Borrowings. Scott mentioned this. I was going to mention it. It's always a good idea to document any type of indebtedness, particularly amongst shareholders or affiliates of an entity when there's not going to be a formal promissory note, maybe from a bank. It's just when disputes happen later or when the IRS comes calling, you have that documentation and it's there, and you can show what happened. This is a little more on ratification. This is what we talked about with the tax consequences. Dividends, distributions, employee bonuses. It's a good idea to document these just to avoid any unintended tax consequences. Shareholder agreements and LLC agreements or operating agreements. Oftentimes, when we draft a buy-sell or an operating agreement, we will have buyout provisions upon a triggering event such as a death or a disability of a shareholder or a member. Frankly, the best way to handle this is for all the shareholders to agree upon a value and attach that as an exhibit to the agreement. That value, assuming you can do this, what we generally like to do, and the best practice is to put some kind of a expiration date of that value. So that value becomes stale if it's not agreed upon by that. For example, that value is good for 2 years. If it's not, if the triggering event should happen 2 years or after, that value would be stale, and there'd be a complex, convoluted formula to determine the value. We try to avoid complex, convoluted formulas when we can. So it's just good practice to meet, talk about what the value is, and update it on an annual basis, just to make sure it's attached.
However, if the shareholders have decided for whatever reason to use a formula approach, that formula needs to be looked at because it may be based on economic conditions that existed when the contract was executed. Those conditions no longer work. The industry has changed, and most importantly, if the funding is no longer there and it becomes a balance sheet funded buyout, that's something that the principals need to be addressing in advance, and if they don't address it, likely their secured lender will force them to address it.
Thanks, Guy. So we're slightly switching gears here from, we were talking about the good housekeeping, more affirmative actions and meetings. This is more, reviewing key documents, really for the purpose of identifying dates and deadlines and other, things to be aware of. So, that's the next few slides are about some of the key agreements and documents a small company should be reviewing. The whole goal for all this is to avoid surprises. You don't want a deadline to come and go that you didn't realize was coming and going, and lose a lease right or an option right or something similar to that as a result of simply failing to take a look at your deadlines and your documents. Loan documents are obviously some of the small businesses' key documents. Covenant compliance. Every loan document I've ever been involved in has financial reporting requirements, and they usually require a company to submit the company's financials to the bank within a certain number of days, whether it be 90 or 120 or 60 after the end of a calendar year, assuming the company keeps a calendar year. You want to know what those are. You want to know what has to be delivered, and you want to make sure you deliver what's required. Failing to do that is a breach of your loan documents. There's also another. Most commercial loans, whether it be a real estate loan or a line of credit, have performance covenants. Whether it be a debt service or borrowing base or whatever. It's a good idea to review your numbers and kind of see where you're going to fall if you can. Because the key, we represent a lot of banks, and I can tell you, banks don't like surprises. It's good to know where you're at. It's good to communicate with your bank and take a assertive, proactive approach. Financial reporting, a small business, this is, they're probably I would hope they're keeping financials and doing pro forma projections, so clearly that's something that should be done anyway. UCC continuation statements is on here. If a company's a secured party under a UCC, that does have an expiration of 5 years. If you don't pay attention to that and file a continuation within that 5 years, you lose your priority rights, and your secured interest can be primed by anyone else that would file in the interim. And this isn't on the slide, but I'd mention, if you have judgment liens or mechanics liens or any other types of liens, these usually have expiration dates as well. So good idea to docket it, have your law firm docket it, pay attention to these dates, and figure out a course of action if and when this expiration comes for any type of lien or security interest. Another key document to review are leases. Leases usually, especially real estate leases, usually have a lot of key dates that are very time sensitive. For example, you may have an option to renew, you may have an option to terminate, you may have some renewal rights. These usually come with some certain date, whereas you have to, a tenant, as I'm referring to tenants for the most part, has to submit some kind of a written notice either to exercise its rights or to not be stuck with an additional term. So, for example, a common lease term would require a tenant to exercise in 90 days prior written notice prior to the expiration of the current term in order to exercise a renewal right. Could be vice versa. Could be if they don't submit written notice of his intention to terminate by that 90-day period, they could be stuck in for an extended term. So it's not hard to do, and it's important concept to keep in front of you is the time-sensitive deadlines under leases. CAM expenses, for any of you that don't know, is common area maintenance expenses. This is additional rent under a lease. Oftentimes, a lease for a multi-tenant building will have CAM expenses, but a tenant will have a right to audit those expenses and challenge them. These almost always have time-sensitive deadlines with very detailed requirements on how you can and cannot do it. It's important to note these deadlines because you lose your rights if you don't exercise them. Insurance certificates, my last point is oftentimes under a lease, and your loan documents for that matter, you're going to be required to provide evidence of insurance to your lender or your landlord. You may have an affirmative obligation to provide updated certificates in your documents without notice from the landlord or lender, and could be a violation of the terms of your agreement if you don't do that. So just a good thing to note to pay attention to, do we need to provide updated insurance certificates? Once again, not a difficult thing to do, but you could be in violation of your documents if you don't do it. I think, Scott, were you going to talk about form agreements?
You said it was boring. I think it's fascinating. I don't know whether anyone else in the room thinks it's interesting, but I think it's fascinating.
Good minds think alike.
I'm going to skate, I'm trying to think of a male skater. I'm going to skate Brian Boitano-like through the rest of my, there's got to be more current skaters, through my outline. Employment agreements. Many employment contracts are tied to the calendar year. And now is the time, actually last month or the month of October was the time to look at the date that's necessary in order to provide notice and avoid an automatic renewal. If you have an employee that you'd rather not keep, the time for opting out of the evergreen clause is now or 2 months ago perhaps. Same is true for vesting. A lot of times vesting schedules are tied to a calendar year end. And sometimes those vesting rights can end even if a termination is without cause. So if you're at risk of being saddled with paying some phantom equity or granting additional shares pursuant to a vesting schedule to an employee who you don't think is part of your long-term future, now is the time. Salary review historically is done at the end of the contract year, again coinciding with the calendar year. Bonus calculations also are done. At this time of year, typically they're done with the bonus paid within 60 days or 90 days of contract year end. If a preliminary calculation shows that a substantial bonus is due and you know that you're not going to have the cash to honor that obligation, now is the time to perhaps negotiate those terms. Computer software agreements, license agreements, maintenance and support agreements, website hosting agreements. The scope of services may change over time. If there are upgrades built in that you don't need, now's the time to address those. If there's a stale fee schedule and that a contract has gone on for years and years, and this is really something for the provider of the services to be attuned to, but it goes both ways. If there is a reduction in scope of services and the fee schedule remains as it has been for the past 5 years, it needs to be looked at and amended. Purchase and sales orders is something that Ron Friedberg will be speaking about later. I only wanted to point out something that I don't think is covered in Ron's outline, but will be the subject of a client alert early next year. It's the inadvertent contract through exchange of emails. There are some recent cases that are sort of scary. Most of them are in the residential real estate context where there are email exchanges going back and forth. Yes, I'll sell you the house for $50,000. No, it's $50,001. Okay, but there'll be some supplemental terms and conditions. I'll send you the addendum. Courts have ruled that the agreement was made through the exchange of emails, and that the addendum was a proposed amendment to it. But the kernel of the deal, the contractual obligation arose merely from the exchange of that email. We have been encouraging some of our clients to adopt disclaimers, saying that any email correspondence does not give rise to a binding and enforceable contract. And if you'd like for us to work with you in developing a disclaimer, either for you or for clients of yours, we'd be glad to do so. The intellectual property, looking at the website, the terms of service, again, needs to be freshened up. I'm not sure that people are carefully studying privacy policies anymore, but it's important to police that. And there should be a point person, for that. Looking at your intellectual property portfolio, taking stock of it, looking at your trademarks and copyright. Is everything still registered? Does something require renewal? Are you using the trademark designation that you paid handsomely for? This is something that a lot of clients forget about. You go back and forth with the trademark office with office actions that go 6 months, and you've paid the attorneys who knows how much money, and then you don't put the R, the circle R. That's what you paid for. That gives you valuable rights outside the scope of this seminar. But it's a good time to remind yourself of that. Similarly, if you've got casual independent contractors doing creative work for you, and you don't have a work for hire letter or a clause in your contract that says that this is the work of your company and that the author is surrendering ownership of it, the law states, copyright law states that it belongs to the creator. So we encourage our clients to look at those contracts to make sure that there is a work for hire clause in each of those contracts. The domain name portfolio, these two need to be monitored, updated, make sure that there's current registration, are any names expiring. You know, are there any parties in your website? Take a look at your website. If you've got people in your website, photos, and they're no longer there, or there's reference to them, it's awfully embarrassing. We've encountered that ourselves. No longer. We wind up using headshots of people, and oh boy, that person lost a lot of weight. Or, we don't want to.
I was
Eric,
6'5" in one version.
Yes, you were 6'5" and 260 pounds. Eric, we don't want to do that again. The record retentions policy, and Peter Turner mentioned at the very outset that this is very important. The benefits of compliance with a good record retention policy are lost if compliance is intermittent or if compliance is non-existent. You're sometimes better off not even having one if you're going to ignore what you put in place. But what is put in place typically covers three categories: the so-called must-keeps, the want-to-keep, and the destroy or delete. The must-keep is driven in part by the need to comply with federal and state regulations. There could be industry-specific regulation. The one that jumps out at me right now is transportation, but there are so many others. There are requirements for maintenance of employment records that Seth can talk about at a later time, because we are being pressed for time. Of course, there are taxes, and the holding period for that ranges from 3 to 7 years. The most important component of it from a litigator's perspective is the so-called litigation hold. It does no good to adopt a record retention policy when litigation is pending or litigation is imminent. You need to have that policy in place well in advance, and there are federal regulations governing the litigation hold, federal rules of evidence, and they are being adopted. I'm not the litigator on the panel, but they are being adopted in substantial part by the courts in this state. You need to establish clear procedures for compliance and enforcement with the record retention policy that you do adopt. Now's a good time for a short plug. We have had occasion in the past couple of months to prepare record retention policy for clients in the manufacturing and service sectors. It's not a one-size-fits-all. In the manufacturing sector, evidence of quality of goods certification becomes very important, and those should be held on to for a long, long time, because you never know when a product field failure will occur. It's not a good idea to save everything. That's not cost effective. It's not serving any legal, business, or administrative purpose, and it could, in the case of litigation, add to your burden, where you'll be digging and digging, and there's no cutoff to the records. Not one of us on the panel is a certified specialist in taxation. We did have Mario Fazio with us earlier this morning, but he had to leave, presumably to attend to pressing year-end tax planning matters. But he did prepare, and it's included in your materials, a very helpful short article captioned Year-End Planning for Businesses. Some of you may have already received it. If you haven't, you will electronically. You have it here. I wish to point out only the bonus depreciation for capital purchases in 2013. This is on page 2 of the short article captioned Year-End Planning for Businesses. The deductibility of certain qualified leasehold improvements. It's never too late in the year to establish a DISC, a domestic international sales corporation. We formed one last year at this time for a manufacturing client, and it resulted in savings of over $30,000. So the few $1,000s spent with us to form that entity were well worth it. Deducting losses by members of LLCs to avoid the passive activity loss rules under certain circumstances. This is something that if you or a client of yours is primarily a passive investor but had some meaningful input, there may be an opportunity to avoid the passive activity loss rules. And our estate planning department is not represented in on this panel, but it's always the right time of year to think about annual gift planning. There are two other tax pieces included in your handouts. Both of them were adapted from something provided by Bloomberg News Service. They're excellent, and I would commend them to you at your leisure. Finally, the insurance audit, you should be speaking once a year, and now's a great time of year to do it if you haven't already, with your risk management personnel. If you outsource that and you have an insurance agent that you rely on for that, those are some of the things that you should be looking at each and every year. Not listed there are accounts receivable insurance, which is akin to a factoring arrangement in some cases, but it's something that's become attractive, and environmental insurance, which is cheaper than it used to be with far fewer holes. And with that, I'm going to turn it over to Ron to speak on purchase and sale agreements, purchase orders, and the like.
Thanks, Scott. Good morning, everybody. I wasn't going to talk about this, but Scott brought up the litigation hold issue, and as a litigator, I can tell you that that is a very emerging and prominent area in the law right now, especially with all of the plethora of information, and particularly electronically stored information, texts, emails, cell phone records, all sorts of things. And if you don't comply with a reasonable records retention policy in a litigation context, it could range from something as, not so drastic as an adverse jury instruction that a document that should have been produced but wasn't, the jury could presume that that would be damaging to your case, to a more extreme case of, if you're a plaintiff, it could result in dismissal of claims or claims, or you're not permitted to present evidence to prove those claims, to, if you're a defendant, possibly a default judgment, or again, you can't present evidence to defend against those claims. So it really is important to maintain documents in accordance with a record retention policy, especially if you're in a litigation hold premise where litigation is imminent or actually exists. This program is called It's the Most Wonderful Time of the Year, and generally for litigators, it is the most wonderful time of the year because courts generally don't schedule trials around Thanksgiving, Christmas, Hanukkah, New Year's. If you ever want to see a ghost town, go to the Cuyahoga County Court of Common Pleas between Christmas and New Year's. Having said that, my first trial this year started January 2nd, so it wasn't necessarily the most wonderful time of the year for me this year. What it is the most wonderful time of the year for you to do, and what I can help you doing, is reviewing purchase and sale agreements, whether you're in the business of selling goods, services, real estate, what have you. Everybody in this room sells something and buys other things. And by reviewing the contracts that you use to govern the terms of those transactions, you can really help yourself if you're in a dispute and end up having to come see somebody like me. Brian alluded to part of a saying, an ounce of prevention is worth a pound of cure. I can tell you that in 99.9% of the matters that I'm handling in a litigation context, the things that we're arguing about, if they had been spelled out more clearly in an agreement, would have, if not avoided the dispute, certainly have streamlined it. Now, granted, you can't plan for everything. It's easy to Monday morning quarterback, especially if it's the Cleveland Browns and you don't even know who the quarterback is going to be on Sunday. But there are certain things that you could put in your agreements just to have some certainty. When you're a seller, well, let's look at when you're a plaintiff and you come to me and you want to collect money from somebody who owes you money. there's certain things that you could have in your agreement to make that process more palatable. Because my job when I represent plaintiffs is to, well, my job is when I represent anybody, is to get you to a resolution of your dispute as quickly and as cost effectively as possible. That applies across the board. But when you're looking to collect money from somebody, my goal is to make you whole or as close to whole as possible. So in terms of reviewing your purchase and sale agreements, there's certain provisions that you could put in there to make that more likely. The first thing is providing for interest. Let's take a $50,000 dispute. If one of you comes to me and says, Joe Blow owes me $50,000, I want you to sue him and collect that money. If there is no provision in there that you're getting interest on that money or attorney's fees, which is the second bullet point, it's going to be virtually impossible for me to make you whole because you're going to be paying me out of that pot that you're seeking to collect. One of the ways, or two of the ways, to avoid that problem is to include an interest provision in your agreement. And a lot of times you'll see, and we can go to the next slide, Ned. A lot of times you'll see on an invoice just interest due on past due accounts at 1.5% per month or 18% per year. I can tell you that if that is just in an invoice and it's not acknowledged or signed by the party you're seeking to enforce that against, generally courts will not enforce that. So if you want to collect interest, put it in your agreement and saying interest on past due accounts shall accrue at X% per month or Y% per annum. And if it's a signed agreement, courts will enforce it. I remember the good old days where the Ohio statutory prejudgment interest rate was 10%, so this wasn't as important. And I think everybody would agree that 10% return on money that's owed to you is a pretty good deal these days. But for the last several years, Ohio ties their interest rate to, I think it's a short-term treasury rate, and they announce it October of every year. Right now it's 3%. So as a matter of contract law, you can get prejudgment interest in Ohio at 3%. But if you put something in your agreements that provides for a better rate when you're a plaintiff seeking to get money, that will make it more likely than not that I, as your lawyer to get you what you're owed, can make you whole or certainly closer to whole than you would be if that provision wasn't in there. Attorney fee provisions. In America, we have the American rule, which is each side pays its lawyer unless there is some statutory basis or contractual basis for fee shifting. In most cases, you can provide that if you have to sue on your agreement, not only do they owe you what is due and owing under the contract, but they are liable for your attorney's fees. That's enforceable in most cases. Now courts are going to imply a reasonableness. You can't just run the meter incessantly and wastefully. But again, if you are a person who is seeking recovery for amounts due and owing, if you have an attorney fee provision, knowing that the other side is not only on the hook for what they owe you, not only on the hook for their own attorney's fees, but also potentially on the hook for your attorney's fees, that in many, many cases will facilitate a quicker resolution of a dispute. I could tell you, you all know that attorneys are expensive. I can tell you that it's more and more common in these cases where it's not so much the merits of the case that will resolve a dispute, but the cost of either pursuing the dispute or the cost of defending it. So if you have those fee shifting provisions in it and you know that both as a plaintiff or a defendant, that a lot of times will facilitate a resolution. I have a case right now which involves a complaint under a lease where I'm defending it. I can tell you that the the merits of the claim are, to use a non-legal lease term, BS. The problem is this particular lease, which we didn't draft, does not have a fee-shifting provision, and it is going to cost more for my client to litigate the dispute than to go to court and prove it's right. If that fee-shifting provision had been in there, we might take a different tact and say, well, we're going to go to the mat with these guys, and not only are we not going to owe them what they're claiming we owe them, but they're going to pay our attorney's fees. So it's really something that you want to look at and put in your purchase and sale agreements. Forum selection clauses. Generally, you can say in your agreements that if there is any dispute, here's where we're going to adjudicate that dispute. And as long as there's some reasonable relationship to where you pick and where the transaction occurs, courts will enforce that. I tell my clients, I like the home games. I like to litigate disputes in Cuyahoga County or Northeast Ohio. I have a case right now where there is a forum selection clause in the contract which you're disputing, which says that all disputes arising under the parties' agreement shall be determined in the courts of Washington County, which is Marietta, Ohio. That's a 3-hour drive for me and my client. And, you know, that's time, and time is money. So if you want to make it a home game, and there's some reasonable basis for including those types of provisions, you can provide that all disputes shall be adjudicated in the courts of Cuyahoga County. We actually have in our fee agreements, which many of you have seen, that disputes are determined in the Bedford Municipal Court or the courts of Cuyahoga County. It's enforceable. You can put those provisions in your agreements. Jury trial waivers are also enforceable. If you are going to go to court, I can tell you that a jury trial is way more expensive and way more time consuming than a non-jury trial. So if you are going to go to court, you may want to consider putting a jury trial waiver, which is even more palatable now in Cuyahoga County, for example, because we have a commercial docket. I handle commercial litigation, and there's a select few judges, and they're expanding it in 2015, but there's a select few judges that specialize in commercial disputes, and they're generally skilled in commercial disputes and will handle them fairly and cost effectively. So if you're going to go to court and you don't want the time and expense of a jury, you could put a jury waiver provision, and those generally are enforceable. There's also mediation or arbitration provisions that you could put in your agreements. I am a big fan of alternative dispute resolution. I think mediation is terrific, and you generally can't force parties to mediate unless you put it in a contract. The nice thing about mediation is nobody can impose a decision upon you, whether you're the plaintiff or the defendant, that you don't agree to. And so it's a good process, and I encourage people to put it in their agreements. Arbitration used to be a very low-cost alternative to litigation. I'm not sure that's so true anymore, but it's still something to consider if you want to stay out of court. The nice thing about arbitration is once a decision is made by either an arbitrator or a panel of arbitrators, it's relatively non-appealable and final. So where it still does maintain its cost effectiveness is that once you get a decision, you're done and you're not looking at appeals. So it's also something to consider. I'm a big fan personally of mediation. Arbitration, I can take it or leave it, because a lot of the cost-effective tools in arbitration have gone out the window because arbitrators, you pay for arbitrators' time. A lot of the discovery that usually was by the wayside, went by the wayside in arbitration, has kind of crept back in. So it's something to think about, and if you want to talk about the pros and cons of an arbitration provision in an agreement, you can call me or someone else at our firm. Some of these other things, and I think we're a little time crunched, but obviously if you're looking to collect money in terms of security, There's personal guarantees and mortgage or security interests. Obviously, it makes no sense to throw good money after bad, and if you're chasing an entity that is judgment-proof, and you can't go through the pierce the corporate veil argument, which is a very difficult burden to meet, even if you don't have good records, and I'm not suggesting you don't have good records, but it's still a high burden. It's nice to have a personal guarantee or at least a mortgage or security interest to provide some security for the debt that you're going after. Disclaimer of warranties and limitation of remedies and exclusion of damages. Those are things, the UCC, Article 2, which governs this purchase and sale of goods, those are things that are governed, that are statutory, but certainly when you're selling goods, you can disclaim warranties, such as the warranty of merchantability and fitness for a particular purpose. You could limit remedies, saying the only thing that we're obligated to do is repair or replace any defective goods. You could exclude damages such as consequential damages or lost profits. You basically want to make the realm of uncertainty as small as possible and the sphere of certainty as large as possible. The battle of the forms, I'm not going to, because we're pressed for time, I'm not going to get into that as much, but basically what that is it's kind of dovetails what Scott was talking about, where you have a series of email communications going back and forth. This is when you have the quotation, purchase order, and there's conflicting terms, and there's things that we can do both on the seller side and the buyer side to make sure that you know what terms are part of your agreement, which are not. Because if the terms are different, you're going to get into a big argument as to which terms govern. And for example, that form selection clause in Washington County that I was talking about, that was in a battle of the forms case where we're arguing about whether it's in the contract or not. When payment terms are different. One term might say payable within 30 days. One might have well, you're only going to get paid if my customer pays me. Obviously, those are conflicting terms that you want to avoid so you know what the terms and conditions of your agreement are. Once again, an ounce of prevention is worth a pound of cure, and if you at year end, or any time, but especially at year end, look at your purchase and sale agreements and put these types of provisions in and put some certainty and make what it could be, what would otherwise be gray, more black and white. It will not only help you, but it will help us if you have to come to us to either collect money from somebody or on the defense side, avoid paying to somebody. Thanks.
Ron, just one point. The battle of the forms is probably a morning in and of itself, but the battle has moved to new arenas. You know, it used to be, and several of us in the room remember this, where the reverse side terms and conditions in print that you cannot read for 4 or 6 font. That has sort of given way to the electronic battle of the forms and terms and conditions that are actually made part of someone's website, and that case law is emerging as well. The concepts are the same, but it makes it a little bit more difficult than before to declare a clear winner of that battle of the forms.
Okay, so I'm here to talk to you today about some preventative measures from the employment side of things, and the old saying that we had up before, the best defense is a strong offense, and not to pile on the Browns, but they clearly don't get that. But hopefully, as a result of going through this in light speed and getting you in and out of here, we will prove to you that that is the case. So the first slide, I'm just going to skim over because these are all the things that I think you should put in place or your client should put in place in 2014 to put you in a better position to avoid unnecessary employment litigation and claims with our friends at the EEOC, the OCRC, the DOL, and various other fun government agencies that we get to deal with in the employment group. So real quick, we're going to go through each of these in more depth, but employment applications, handbooks, employment agreements, non-compete, non-solicitation agreements, severance agreements, supervisory training, ADR programs, and employment law audits. So employment applications. It's remarkable how many people cheap out on employment applications and they just go to Office Max and they pull something off the shelf, or they find something on the web, or they steal somebody else's stuff, and they've had the same employment application for since disco was hot. And I get these employment applications and they ask all kinds of, I don't have to beat around the bush, illegal questions like, what year did you graduate from high school? Or what church do you belong to? Or who knows what else? Well, those applications went out, again, when white suits were cool. And if you still use, or if your clients still use employment applications from that era, they're illegal on their face, and they're going to instantly get you into trouble. Have the applications updated. It's a fairly simple process, and there's lots of good stuff that you can learn early on with a good employment application that you're not going to have in your disco era ones. So I list a bunch of them. You find out about the educational background. All of this stuff is very helpful to, as my friend who's also a client has one of the better background screening companies, he's got a statistic that would tell you that over 90% of people lie on their resumes. So are you going to believe that someone graduated from Harvard magna cum laude, or are you going to ask it in the application and have a reference check procedure to see if that's actually the case? Prior employment, when you see a job and then you see a gap of 3 years and then you see another job, well, what happened in those 3 years? That's important information to know as well. References. If they are giving out references, you have the right to check them. Most people are not trained HR professionals, and you can glean a lot of really good information by following through on reference checks. You'll find out about those in the application. Skills and experience. How many people have seen on people's resumes they're completely proficient in Word and Excel and Office and all these things, and you get them in the seat and they know nothing about even how to turn on a computer? If they said that in the application and you sit them in the chair and they don't know how to do their job, you've got an instant ability and another document in your arsenal to say, hey, you lied to me from the get-go, I've got the right to terminate you for it. Restrictive covenants. Even as early as the employment application, you can put certain restrictive covenants in your documents that can be binding. I don't want to rely on an employment application because you haven't really given anything yet. However, it should be part one of what's coming next, which are actual restrictive covenants, and then you've got kind of a belt and suspenders approach to making sure that there's no question that employees knew when they came through your door they were going to be subject to some restrictive covenants. Criminal background screening. This is a real hot area right now with the EEOC, where everyone is familiar with the application question that says, have you been convicted of a felony in the last 7 years? Nod, everybody, if you've seen that before, yeah? So the EEOC hates that box. They hate that question. And they are going after not just mom and pop companies, they're going after huge companies, suing them because they believe that when you ask that question, it's inherently discriminatory. Because a higher percentage of minority applicants, the statistics they would argue would show you, have a greater incidence of criminal backgrounds, you are screening them out of the process early on, and therefore that practice is discriminatory. Now, if you want to read some really funny judge-made case law, there's a judge in Maryland who took the EEOC to task and basically said that their math was fuzzy, would be doing a disservice to what the judge ripped into the EEOC about. Basically said that their EEOC math was worthless and that their whole premise for this ban the box is worthless. You would think that a strongly worded federal court judge decision would stop the EEOC in its tracks. What did they do in reaction to that terrible decision where tons of attorney's fees were paid because the case was deemed frivolous? They sued 4 more companies. They don't care. They have the federal mint behind them, and they're going to absolutely continue to sue, and it's working. At least 11 states, maybe 12 at this point, have passed ban-the-box legislation, requiring employers not to have that question on their application anymore. Ohio has not gone yet. Yep.
Are you allowed to make a hiring decision based on not hiring somebody based on a previous conviction?
Say that again?
Are you allowed to make a decision to not hire somebody based on a previous conviction?
Okay. So what does the EEOC want you to do? What the EEOC wants you to do, and I represent a couple of large staffing companies, it's a nightmare for them, because let's say Lubrizol wants my staffing company to hire 200 employees for them. So the staffing company knows Lubrizol will not hire felons. They know it. It's an absolute non-starter for them. They've got trade secrets, they've got all kinds of proprietary information, they've got precious metals, they've got chemicals, they've got expensive stuff. They know Lubrizol won't accept any candidate from them who has a criminal record. So, do you want to take on that lawsuit with the EEOC? My staffing companies don't, so they take that box off of the application question, and they have to interview for 200 people that they're trying to employ. Instead of interviewing 300 people, they may have to interview 1,000 people now and take on all the waste and the cost and the expense. And then once you interview the individual, you can ask the question. But you have to have a job-based reason for asking the question even at that point, according to the EEOC. And keep in mind, this is not a law. This is a rule that the EEOC just decided. And you almost have to tip your hat to President Obama. He's finally figured it out. He can't legislate anything. So he has enforced the EEOC, the DOL, OSHA, all the government agencies who can enforce their own rules to do just that. They're making rules and they're enforcing them. So in answer to your question, you can ask the question and you can deny employment once you talk to them. But the businesses have to take on all the expense and costs that go with it. But good question. I mentioned an aggressive tactic that some employers are starting to take, and that is on the application, you can actually have a clause in there that says instead of a normal statute of limitations, which under Ohio law, 2 years, 6 years, depends who you talk to, for employment discrimination cases, you can shrink that statute of limitations down to 6 months or something much shorter, just by the fact that they applied for a job with your company and they understood it when they signed up. Also increases the chances that you're not going to get sued. Okay. Handbooks. I do a lot of this work. There are a lot of other people, let's be kind and call them charlatans, out there doing this work out there. Payroll companies who will tell you, well, for free, for no cost, we'll do a handbook for you. And one of my homegrown, I'm from Rochester, New York. There's a large payroll company out there that shall go nameless from my home city that starts with a P, that will put out an employee handbook that is not ready for Ohio law. It has very little, if no, Ohio law provisions in it, and in some cases contradicts Ohio law, but they continue to pump out this handbook, and I see them all the time, and I have to revise them because they don't apply here. Do not steal another company's handbook. They're not your handbook. Do not take a handbook that was created in California or Oregon or Montana, any of our nuttier states that have bizarre employment laws that they're very nice places to visit, but you don't want their employment laws in your handbook. Customize your handbook. It's a very low cost, very easy process. We can do it for anywhere between $1,500 and $2,500, depends on the work and the number of locations. And it's good for the employer, always, assuming your supervisors follow them. I'll get to that in a second. So handbooks are your greatest friend. They will absolutely pay for themselves multiple times over because the EEOC, the OCRC, workers' comp, unemployment, if you've got that document in place and you've got the authorization form showing the employee knew all about it and hopefully they were trained by someone like myself or a trained HR person on the handbook policies, you got them. And that protection is worth its weight in gold. And I list out a whole bunch of the various provisions that I put in just about any handbook. Just a couple of them off the top. At-will disclaimers. Handbooks should have at-will disclaimers throughout. There's very good case law in Ohio that says if your handbook says that, you can basically ignore the offhanded supervisor comment that says, hey, Joe, you're a great employee. You keep doing what you're doing. You've got a job here for life. If you've got a good handbook with at-will disclaimers that say these little promises mean nothing, that's a good defense to those kind of claims. Harassment policies, of course, you need to have EEO policies and harassment policies in place. More importantly, you need to train your supervisors on that, and we'll get to that more in a second. FMLA. Big FMLA, what does that stand for, everyone? It's the Feed My Lawyer Act. It's the greatest piece of legislation for defense lawyers probably ever. It's an atrocious law to administer. However, you need to have 50 employees or more to actually qualify for it. If you stole someone's handbook or you took a handbook off the internet, it may have an FMLA provision in it. If it does, the law is pretty clear. You put it in your handbook, you've bought the FMLA. You do not want the FMLA unless you are eligible to be covered by the FMLA. Okay? FLSA exemptions, wage and hour DOL, they're going crazy these days. You need to have provisions in your handbook that require employees to come to you first to fix their wage and hour issues. It's a great way to, number one, fix these things before they go to an outside agency to alert the government to it, but it's also just smart HR to fix problems early on that are probably very little in scope before they become wildfires that are out of control, dealing with hundreds of employees that have the same problem within your organization. ADA policy. I didn't used to put this in handbooks, but now we do. Why? The ADAAA, lots of A's, but they amended the ADA in 2009, and who here has a sore back? You're disabled. All right. Just about anything constitutes a disability these days. So your supervisors need to be trained exactly on how to deal with the employee coming to them and saying, I've got this malady or that malady, and how to react. The government now, they do not want you to even ask the question if the person is disabled under the law. Believe me, they are. You have to deal with the step 2 part of the equation, and that is, can you accommodate that disability? Whether it's a sore back, a toughed out hammy, a sprained ankle, I don't care, you're disabled. Can you accommodate it? Okay? Breastfeeding policy, social media policy. Again, you have to be eligible for the breastfeeding policy. That got slid in with a piece of healthcare legislation a while back, and I didn't think this needed to be a law. I thought people would actually have the common sense to do this kind of stuff until I had the fortune of having an HR friend in Columbus who worked for a rather towel snappish college fraternity style law firm that thought it was very funny to create their own, what they called the boob room, and it was essentially a broom closet that they converted into a place for women to pump milk, and it was maybe 3 feet by 3 feet, and they posted all kinds of pictures of women's breasts all over the wall and called it the boob room in big bold letters. And my friend, the HR person, came to the managing partner and said, you can't be serious. We can't do this. And he said, well, if you don't like it, there's the door. Why don't you quit, sweetie? And she did. And we threatened to sue them. And before she left, I had her take pictures of that great room. And that case, Jones Day on the other side, settled in less than a month for big dollars, and that HR person didn't have to work for a few years. The breastfeeding policy, very easy, very simple, makes sense. Have a room, have it private, have it be able to be locked, and don't do what another company did, have video cameras in the room. That was a bad lawsuit, too. Social media policy. I'm getting a lot of these days. They're very necessary, I would tell you, in this day and age when employees forget about using your computers during the workday. Even if you have protections on your computers, they can just pick up their phone and do the same thing that they could do on your computers by phone. You need to have policies in place that tell people right from wrong. Employment agreements. You're not going to hear me say that your maintenance crew needs to have employment agreements, but if you have employees that can hurt you, or if you have clients with employees that can hurt you in some way, if they leave you, then having an employment agreement in place is far better than not. Handbooks are wonderful things, but one thing they are not contracts. So if you want to enforce something like a non-compete, you can put that in your handbook, but it's not worth the paper it's printed on. It's nice to have in the handbook, it's a reminder, but it's not a contract. You need a standalone agreement for that. And so if you've got employees that could, if they left you, solicit your clients, solicit businesses, steal clients from you, steal confidential information, proprietary information, those are the types of employees I'd like to see with employment agreements. Can you have an employment agreement with an employee who is an at-will employee? Absolutely. Absolutely. We draft them all the time. And the law is very clear now. You do not have to hand them $100 like you used to, or $1 or $10, and say, here's some money, sign this contract. Now there's consideration for the agreement. Their next day of employment is sufficient consideration to give them an agreement. So you can do it midstream, and I would encourage you and your clients to do it. So I list off a bunch of the elements of an employment agreement here. Only one I'm really going to talk a little bit more on is the non-compete, non-solicitation provisions. We'll get to those in a little bit. Confidentiality, trade secret, at-will versus just cause. So at-will versus just cause. We are an at-will state. We are not a right-to-work state, but we are an at-will state. At-will, you can terminate an employee for any reason under the sun, as long as it is not an illegal reason or for retaliatory reasons. That said, employees can leave you at the worst possible time. We've got a bunch of accountants in the room, yes? Yes. Imagine if 20 of your best accountants decide to leave on April 12th. That would be pretty bad, wouldn't it? Want to know what you can do about it? Nothing. And that's the balancing act that keeps at will the law of not only the state of Ohio, but 49 of the 50 states. Want to guess the wacky state that doesn't follow at will employment? Good guess, but wrong. I mentioned it before. It's Montana. Montana. But even they follow a version of at will employment. So those are the things you need to think about when you're doing employment agreements. I list out a bunch of others. Severance and general release provisions, of course, can also play in there too, and I'll get to those. All right, non-compete, non-solicitation agreements. Are they enforceable? Absolutely. In the state of Ohio, there's very good case law that will tell you that they are enforceable. That said, if your non-compete says that you cannot practice accountant work, accountancy in the entire planet, you might have some trouble enforcing that. It's far easier to enforce a non-solicitation agreement than it is a non-compete, and it makes all the sense in the world. Do you want to tell an accountant, for instance, that they cannot practice what they've spent their entire life mastering? Judges don't want to pull that trigger. That's a tough one. However, will judges protect the clients that that accountant came into contact with while they were at the firm? Absolutely. That makes all the sense in the world. And accountants, I will say, got this right earlier on than most people did, and that is they know that people hire the accountant and not necessarily the firm. So lots of accountant non-solicitation agreements that I write or that I review have in there automatic, what I would call liquidated damages provisions. So they say, look, we know that you're going to go out there and be an accountant somewhere else. We even will acknowledge there's a chance that the client is going to follow you and not stay with us. If that happens, you owe us X. And it's usually some percentage or 100% of their last year's billings or 2 years or 3 years. Okay? Makes all the sense in the world, and it's much easier to enforce because, again, it makes sense to a judge. So those kind of provisions are common. Yeah?
What if the client follows you without any solicitation whatsoever?
Yeah. I doubt it. I immediately dispute the premise because what, you didn't say at all that you left? They just guessed where you landed? You probably had a conversation with them. But let's leave that to the side for a second. The answer is it doesn't matter because most non-solicitation agreements, at least non-solicitations that I or my partners would draft, would say direct or indirect solicitation. You can't accept work from that client. That's a really good little tweak to most solicitation agreements.
Do you accept new work?
No, no work. No work. You don't want them taking any work from a current client of your firm. So there's very specific good language you can put into these agreements to prevent just that from happening. Blue pencil rule or the black robe rule. You can have the greatest non-compete, non-solicitation in the world, and it's whatever the person in the black robe says it is. They can take out their magic blue pencil and just eviscerate it. They can change it, they can alter it, they can edit it, and the good judges will use that as a club to get a settlement in most cases. They'll say, go outside and get this thing resolved, or I'm going to pull out my magic blue pencil, and you're not going to like what I do to it. Very effective. Must be reasonable in scope. Again, I used the globe example before. You want to limit the scope of these non-competes and non-solicitation agreements as much as possible. If you're an Ohio company and all of your clients are in Ohio, having a clause that says that you're prevented from doing X, Y, and Z in every state in the country is not that great a protectable interest to enforce. Someone's going to question you on it, and you're not going to have a good answer. And I mentioned the solicitation of clients and employees and liquidated damages.
Excuse me.
Yep.
Are the non-compete agreements typically like an all or nothing thing? For instance, I see a clause
Again, it's blue penciling. It's whatever they say it is, but chances are a judge is going to say, well, I'm not going to enforce it outside the state of Ohio. That's stupid. But I am going to enforce it in the state of Ohio, or I'm going to only require the client to not compete with customers that he met or learned about when they were at the firm, or it's going to be some different variation of it, but they're not going to throw the entire agreement out, and probably what's going to happen is you're going to get a somewhat more limited enforcement of the agreement that you have. Yep. Severance agreements. I view severance agreements as a wonderful litmus test for shifty ex-employees. I said shifty with an F in there. Be very careful of pronunciation when you're in the microphone. So shifty employees, you've got an employee that you're not quite sure whether they're going to sue you or not. I love to hand them a severance agreement because in my world, I don't trust anyone who doesn't accept free money. And that's what a severance agreement really is. It's free money. There's no law that says that you have to pay anybody severance, but if you're going to do that and you're going to ask for in return a release and waiver of their employment claims and they refuse to sign it, I don't want to give them any of my free money. I'm going to take that money, I'm going to put it in a bank, and I'm going to spend it on my favorite lawyer, preferably me, to defend what's going to come. Because if they're not going to sign that agreement, they're going to sue you. And it's a really good early way to figure out whether you've got a friend or a foe in that employee. Common elements, I list them all here. Sometimes you might want to throw in outplacement as well as a nice thing to do. Giving severance is not only good from the standpoint of getting a release and waiver, it's good for culture. It's better when employees leave and they feel okay about you because they are going to talk to their friends that are back at the company, and you want at least to have that kind of feel good as much as possible when you separate. Supervisory training, I'm not going to dwell on this too much, but I do a ton of it. And there's good reason. I'm going to teach you a Latin phrase this morning. You thought you were just going to get coffee in Danish, but you're actually going to get a Latin lesson. And that is respondeat superior. So supervisors, anyone a Latin scholar? You know what respondeat superior is? Lawyers do. Cover your ass? No, that is not what it means. Thank you. But respondeat superior does mean that supervisors stand in the place of the company. Now, if any of you know manufacturing, the prospect of a third shift, whacked out, probably drunk supervisor being the head, the face, and the mouth of your company should really scare you. So supervisors are your best friends. They're the first line of defense. They are your eyes and your ears out on the plant floor, and they are also your worst nightmare in terms of having the rogue supervisor who doesn't follow your rules and regulations. So if you have multiple plants, for instance, you don't want general manager of plant A doing things different than general manager of plant C. That's the definition of discrimination. You're treating similar people differently. Training your supervisors is worth it. It's worth its price 16 to 20 times over. You're going to spend a couple $1,000s training those supervisors. It will prevent everything from workers' comp suits to unemployment costs to discrimination suits to you name it. Have your customers or your clients do it. Do it yourselves. And these are all the different things that I would train supervisors on. Safety and health. We have one of the premier safety companies in the country represented here. Biased plug for our client, SCT. But he would tell you that OSHA and the DOL are out in force like never before. And the days of getting deals done with OSHA and the DOL, frankly, is at an all-time low point. They want their money. And there are very few good deals happening in OSHA land and the DOL world these days. You need to have good representation. You need to have supervisors who are trained on this stuff. And when the OSHA or the DOL comes knocking, they know how to respond. And they don't respond with, oh yeah, those are our good CNC machines with the safety locks, and those are our old CNC machines that don't have interlocks because we jammed a key in there and we don't want to have interlocks on those. The minute a supervisor says that, remember my Latin phrase, respondeat superior. He just put your company in a whole world of hurt because that's a willful. Okay? A willful violation of OSHA. So your supervisors need to be trained on this stuff. Union avoidance, I do a lot of that. In the good old days, unions are at an all-time low too, but if you have the fortune to deal with my friends at the Teamsters, UAW, Steelworkers, knowing how to not only avoid getting them to come in, but dealing with them on a day-to-day basis is also key. ADR, I'm not going to spend a lot of time on. ADR programs are great. Ron alluded to it a little bit before. Essentially, this is just an alternative dispute resolution arbitration type clause. The one nice thing about these clauses is that it keeps your matters private. Your company's name doesn't appear in lights. It's not a public document. It can be handled privately, private resolution. That said, Ron pointed out correctly that the cost benefit of these things has shrunk. And the problem with ADR programs is that if they're not drafted very well, you have a very good chance of not only having one fight, but two fights. The first fight is over whether or not your ADR program is even enforceable, and if you have the pleasure of winning that fight, then you get to go through the ADR. So whether or not an ADR plan is right for you or your clients, I would question. But these are some of the things that need to be thought about when you address an ADR program. Employment audits. I gave a talk maybe 3 weeks ago to a payroll company, and I've got 2 to 3 of these employment law audits as a result. It's a wonderful tool, especially if your clients are a new company or they've got a wet behind the ears HR person who doesn't really know everything about everything or wants to learn. It's an opportunity to bring me or one of my partners in to do a holistic, top to bottom, soup to nuts assessment of your forms, your documents. Are you keeping them properly? Are your handbooks in place? Are they updated? Do you have employment agreements? Are your supervisors trained? There's a whole menu of different things that we can do and come in, and again, for a very, very low cost, proactive front end, dividends will be paid for many years to come. The last bullet point there, EPL insurance. You need to have this conversation with your clients. My partner Lester and I have a bunch of cases going on right now, and in one case, the client, maybe less than a year before, decided, this EPL policy, what's it really good for? I'm going to cancel it. And they did. And Murphy's Law, they got sued. And they don't have any insurance protection. And it's a bad case. It's a tough case with lots of depots, lots of work. And had they had the EPL in place, yeah, they would have paid the first $10,000. But after that, it's the insurance company's problem. And you are in a much different position, settlement-wise, when it's your money as opposed to an insurance company's money. So have that conversation with your clients and think about that with your risk managers going forward. It's not as expensive as it once was. Yes, there are exclusions, but you can negotiate some of those exclusions away. You can work in choice of counsel and a whole kind of other things when you are initially buying the product, because that's when you have the negotiating leverage. Lastly, litigation wrap-up. So what are the causes of litigation? If I had to say the number one cause of litigation, it's lack of communication, and that can include lack of documentation. So when employees don't know why they're being fired, or they're getting cross messages, or they're not sure, I've been doing this a long time. I have yet to hear the employee who says, you know what, in deposition, I really was very bad at my job. Every employee believes they're at least mediocre. Okay? They can always point to somebody else who's worse than they are. Okay? So if you know that going in, and you know that the employee believes in their heart of hearts that they're not bad at their job, when you terminate them, they're instantly going to think there has to be some nefarious reason for it. It's because I'm black, or I'm over 40, or I'm a woman, or I'm whatever. Okay? However, if you've notified them all the way along their tenure with you that their performance stinks, their quality stinks, their attitude stinks, their attendance stinks, and there's write-ups in the file, that communication hopefully will serve you well going down the road, and especially if it gets to litigation with the EEOC, the OCRC, or another attorney's on the other side, and you can throw a stack of paper at them showing that the communication was there. The other thing that causes litigation, emotion, lack of respect. Employers, clients of mine who hire a couple of jackbooted thugs to drag their employees forcibly, throw them in the streets, and then follow with a box of their stuff. Generally speaking, that's not the way to handle employment exits, and that causes a great deal of annoyance, embarrassment, making them do the perp walk past all of their coworkers instead of handling it at the end of the day or early in the morning where they don't have the embarrassment. That causes litigation as well. Why avoid litigation? Well, who here has had the pleasure of being deposed before? Who here has had the pleasure of being in a lawsuit before? Okay. I used the word pleasure. Was it pleasurable? No. It's stressful. It's annoying. You've got to deal with me or one of my partners all the time. It's going to take time away from your work, opportunity cost lost, you name it, stress, money. You want to avoid litigation at all costs. And oftentimes, the cost to prevent it, all the things we're talking about today, are low cost as opposed to once you're in it. How to avoid litigation? Pay attention to all the preventative measures that we've discussed today. While it is not a cure-all or a silver bullet, it will certainly put you in a better position to defend and possibly defeat the lawsuit and or get an early resolution to it. I would tell you this, forget about the golden rule with your employees. Move it up even one step beyond that. Go to platinum rule. Treat employees better than you want to be treated yourself. That will go a long way to helping you out both while they're employees and when they become ex-employees. Don't throw them out on the street. Don't make them do perp walks. Don't hire jackbooted thugs to throw boxes at them and do things like some of my clients have done in the past. Mistakes. The best defense, last. I'm going to give you the 3 magic rules of employment law. Some of you who have seen me speak before know that this is absolutely rock solid stuff that is researched and clear. I've written papers on it, years of research, and here they are. Ready? Number 1 rule of employment law, document. Number 2 rule of employment law, document. And number 3 rule, document. However, that last document has an asterisk, and that asterisk goes to the bottom of the page, and that asterisk says, make sure you give me a damn good document. Because a bad document can countermand thousands of good documents. And the case I bring up for that is a tenured professor, a professor who's trying to get tenure at a university, a college that I represented. 3 strikes and you're out. You could go for tenure once. If you didn't get it, you could go for it again. You could go for it again. If you didn't get tenure on the 3rd try, you would never be a tenured professor at this institution. So this professor, Muslim guy, over 40, probably had a club foot or something. He applied for tenure, denied. Stacks of documents. The worst professor ever. Students hated him. Peers hated him. Performance terrible. Didn't publish. Tried again a couple years later. Denied. Same stacks of good documents saying he's the worst professor ever. Nobody likes him. Tries again 3rd year. Fails. Stacks of good documents saying all the same thing. Bad performance. Bad writer. Bad this. Bad that. His tenure application goes to the HR department. A 2nd-year know-nothing HR woman down there gets the tenure application and writes on the top of it in purple pen, ha ha, 3 strikes you're out, happy face. Not to get technical on you, but that is what we call in the legal business a really bad document. That document got blown up to the size of a wall and got paraded past a jury 10 to 15 times, and that one document countermanded hundreds of really, really good documents. And I learned very early on, as a 1st or 2nd year, I forget what I was, give me damn good documents, because one bad one can sink your ship. With that, I will close and say we will stick around for any questions that you might have. We have certificates for those of you getting credits today. Sarah Cox in the back can take care of that for you, and we'll take questions across the panel, and we'll stick around afterwards. Anybody have a question right now? Joe.
On your employment agreements, can you retroactively apply them to employees after they get off their employment? In other words, I have a group of employees who may not have employment agreements in place. I heard you today, the employment agreements and go back to them and have them signed.
Right.
Can you do that?
Yes. So again, you don't have to bribe them. You don't have to give them $1,000. But you do, if you hand out the agreements, you can do it midstream. They've been employees with you for 10 years. Doesn't matter. You can hand them an employment agreement and blame it. There's a great game that I teach my clients to play. It's called Blame It on the Lawyer. Hey guys, you know, our lawyer's telling us that we need these agreements in place. So we're passing them all out. If you have any questions, let us know. Then you got to ask yourself the question, what happens when one employee out of the group refuses to sign it? What are you prepared to do? The answer is, you got to be prepared to fire that employee, because you don't want prima donnas and you don't want one person getting treated different than others. Can you negotiate the agreements with slightly different terms in them? Yes. However, if you get into a lawsuit, one of the things that a crafty plaintiff lawyer is going to do is they're going to ask for all the employment agreements and they're going to look for differences. And they may say that you treated this one differently than this one, and there's nothing wrong with doing that. Some employees are just better than others. Some employees come to jobs with 5 and 6 weeks of vacation time, and you only offer 3. But you're not going to get that employee unless you offer them far more vacation time. You can work that into the agreement. It's a different term, and that's okay. You know, rock stars get treated like rock stars for one really good reason. They're rock stars. So if you got to create different terms for your rock stars, that's okay, but you want to have agreements with all of your employees. Good question, though. Anybody else? Anybody for them? Okay, we appreciate your attention this morning. Thank you for staying with us, and we will stick around for questions afterwards. Thanks, everybody.